Thank you very much, Mr. President. And I will start my brief remarks with a tribute which I paid only yesterday to once more finding myself moved and impressed and enriched by the quality of the wise women and men of the independent bench. But I was even more enriched today in listening to the remarks of the youngest member of the independent bench, and I pay tribute to Independent Senator Helen Francis.
If he's the youngest.
If he's the youngest. And I will give way to him if I misunderstood him, but he started off by speaking to the focus of the bill before this House, and I understood him to be referring to the guidelines that the bill seeks to give to the judiciary, and he used the term enhancing judicial transparency and accountability. And I commend that perception. And it goes back to a point that I often want to return to, and that is the debate. Let me be as neutral as I can be. Let me debate. To the debate that we have on the separation of powers in this place and the other place. And that very wise remark of the independent senator, that the provisions of this bill before this chamber, and therefore asking for the imprimatur of the legislator, the parliament, is a very good, current, contemporaneous example of the true meaning of this separation of powers. That is to say, this executive, of which I am proud to be part, brings to this House, this chamber, a piece of legislation by which the other part of the state, the parliament, will hopefully give its imprimatur in order to enhance judicial transparency and accountability in the exercise of their jurisdiction to grant or not to grant bail. Now that is the working of the separation of powers, where the different arms of state come together under our Constitution. And I pay tribute to Senator Helen Francis. I will return to a couple of the other things that the good senator said, but let me go back to my original intentions in terms of the remarks, a few remarks I want to make. I again, referring to one of our other independent senators, Senator Paul Richards has gone on record, and I am grateful to him for putting on record here today the fact that our statistics show a 60% to 70% recidivism rate in Trinidad and Tobago. And we are talking about that in the context of this bill. And one of the important facts that we are putting on record here today so that this Parliament can maturely exercise its deliberate legislative power is to have the data that speaks to the legitimate aim in order to manage the proportionate exercise of what Parliament is about to do. So thank you, Senator Dr. Richards, for adding that data to our bank of some of the data that we have had put before this Parliament today. And in speaking to the recidivism, of course, the Senator makes the call for Trinidad and Tobago having a more effective restorative justice system in Trinidad and Tobago. And I can give the Senator, if I'm just permitted to comment by way of reply, not strictly on the issue of bail, but to assure the senator that the Office of the Attorney General and the Ministry of Legal Affairs is in active correspondence with the prison service as we work through a conversation with respect to restorative justice and measures that we are hoping to take in that regard. We have in the make as well a parole bill also to deal with an issue which Senator Lachmidial raised, that is to say, the remand conditions that we need to do better with. We accept all of that. Senator Vera has, as one would always expect on another occasion, but I won't go there today. I was tempted.
It was an exception.
I was tempted. Senator Vera embraced the bill with certain criticisms, and I accept that. And while he makes the point that the bill does not address the failings of our education system and societal systems, we accept that this bill is not a panacea for everything that we need to fix in the society. We never said it would. And the amendment that we are seeking here today is just one part of the fabric that we are trying to rebuild for a better society, keeping our citizens safe. We've also had other remarks from other independent senators. If I may respond briefly, I asked her to give way at a certain point to Senator Suniti Maraj, because she was using a turn of phrase that I wasn't following. That is to say, she was making the point that the power that is being given away, and I asked her to give way, and I'm grateful that she did, and she explained that she was talking about, in the context of the power that is being given away, the presumption of the right to bail. Well, I think the answer to that was put better than I could by what Senator Helen Francis said, because we are not giving away a power. We are in respect of a citizen's right to liberty, and the fact that the judiciary from 1898 has always had the discretion to grant bail, seeking to enhance the capability and to provide guidelines to make that capacity, when exercised, to grant or not to grant, more transparent. So we're not giving away any power. We are rather providing guidelines by which properly to assist the judiciary, we the legislators, to assist the judiciary in making their task more clear, more transparent, more accountable by providing reasons, and the reasons would then conduce to whether there is a good appeal or not. We are providing for the right to appeal. So, Mr. President, those are my few remarks of gratitude to the Roman wise bench of the Senate. I regret to have to go on record to say that I hope in the fullness of time and greater maturity, Senator Naked will rise from the abyss into which he descends so often and will pay respect to being a member of an ancient, hallowed tradition which deserves more respect than he gives it every time he stands.
I've warned earlier on, have a seat, Attorney General, the language. Just be careful. Attorney General.
Mr. President, and I was in the process of saying that I'm an optimist at heart. And
Mr. President.
Senator Naked, so the next outburst will be dealt with accordingly. Attorney General.
Thank you, Mr. President. And I was in the process of saying that I am an eternal optimist, and I live in hope that in maturity, Senator Naked will give respect to this House, which it deserves. Mr. President, let me pay tribute to Senator Lawrence Hislop. Let me pay tribute to Senator Renuka Sagramsim Suklal. They have put a rich contribution to the debate we've had here this evening. Let me pay tribute to Senator Sukai. It encourages one to participate in this process when we have the richness of the quality of the bench that the government brings to this place. And let me finally address one or two of the remarks which Senator Jayanti Lakshmidhyal made. She spent a lot of time, Mr. President, applauding the fact, and I congratulate her, she was part of the legal team that took Achille Charles to where it went. And I congratulate her on that. I'm always happy to see lawyers, young lawyers, ascend to greatness. It is an important decision. As I have said of the Suraj decision, this one will be written of in the constitutional and public law books for a long time. But do not let the politics do a disservice to a noble profession, the legal profession. So, while I accept that the government appealed the Achille Charles decision, the government lost in the Court of Appeal and appealed the decision to the Privy Council. That is not a criticism of the government. Governments have to be responsible.
Exactly.
And if we look at paragraph 10 of the Achille Charles decision of the Privy Council, delivered on the 28th of July, 2022, this is what paragraph 10 tells us. On the 17th of February, 2022, the Court of Appeal, Chief Justice Archie, Justice of Appeal Dean Armorer, and Justice of Appeal Holip allowed the respondent's appeal. So we lost in the Court of Appeal. Fair enough. The Court of Appeal in Achille Charles held that the bail provision was not existing law and that the earlier majority Court of Appeal decision in Krishandath Sinanan against the state, 1992, 44 West Indian Reports, 359, was wrong in holding that the High Court did not have jurisdiction to grant bail to a person who had been committed for trial for murder. So let us pause and reflect on that. At the 28th of July, 2022, the law in Trinidad and Tobago was in conflict. Two courts of appeal of the Supreme Court of Trinidad and Tobago, one reported 1992 44 Western Report 359 in the case of Krishandath Sinanan and the state, had held that the High Court did not have jurisdiction to grant bail. And until a decision of a higher appellate court, that decision was binding. On the 28th of July, 2022, when Achille Charles was determined in the Court of Appeal, and the Court of Appeal found that the High Court did have the jurisdiction to grant bail. What you had was the classic conflict of jurisprudence at the same level. It was the duty of a responsible government to take that to the higher court. It would have been irresponsible in the extreme. It would have been a dereliction of executive and constitutional duty for the state not to have appealed that. It had to go to the apex court so that we could get the benefit of the final court of appeal, which at this point in time is the Privy Council, settling a conflict which had existed for 20 years between two courts of the same jurisdiction, the Court of Appeal of Trinidad and Tobago. So don't use the political platform to trump one's trumpet to suggest that the government was wrong to have appealed. The government had to appeal. Let us be lawyers when we have that, the honor to belong to that profession. We have had significant statistics put before this august chamber, Mr. President, and I just want to leave one last word to commend to this chamber the fact of us being on good ground. In the Attorney General against Morgan, 1985, Law Reports of the Commonwealth, page 780, a significant decision emerged out of the Court of Appeal of this country. Some of us are old enough to remember that case. It was the rent restriction case. The respondent challenged the Rent Restriction Dwelling Houses Chambers Act 1981, which had been passed with the required majority in accordance with Section 13 of the Constitution, a supermajority. This legislation introduced a cap on the amount a landlord could charge for rent. The cap applied to properties that attracted rent charges within a specified range. The respondent, a landlord, challenged the constitutionality of the rent control legislation on the grounds that it infringed his right to property and that as it only applied to certain landlords, it amounted to unequal treatment. The Court of Appeal allowed the appeal of the state on the basis that the respondent had failed to discharge the burden of proving that the law was not reasonably justifiable. So let us go back to the reasonably justifiable legitimate aim principle established by the Court of Appeal in 1985 of this country. Critical to the court's reasoning was the fact that the state was able to produce evidence in the form of data to show how many tenants were likely to benefit from the protection afforded by the legislation. So that was a good example in another factual scenario entirely, where the legislature of this country had passed legislation with a legitimate aim to control rents in the face of a runaway landlord class in the country. And one of the landlords challenged it on the basis of being unjustified, and the Court of Appeal, and it was not appealed, held that it was in pursuit of a legitimate aim. The data was before the court to have satisfied the Parliament that it was an appropriate exercise of parliamentary jurisdiction to have capped the rents, and therefore the Rent Restriction Act was upheld as satisfying the 3/5 majority. So that if ever we needed precedent by our own Court of Appeal for what I ask this Parliament, this chamber today to do, that is the precedent. And with those words, Mr. President, I beg to